Pay equity is a fundamental human right in Canada. It means equal pay for work of equal value. In other words, if two different jobs contribute equal value to an employer's operations, then the employees in those jobs should receive equal pay. Pay equity is important because occupations commonly held by women tend to be paid less than occupations commonly held by men, even when the work is comparable in value based on skill, effort, responsibility, and working conditions. This undervaluation of women's work contributes to the gender wage gap. Pay equity is not the same as equal pay for equal work. That's comparing the pay of similar jobs, where women and men are doing the same work. It's like comparing a female truck dispatcher's pay to a male truck dispatcher's pay. Equal pay for equal work is protected under the Canadian Human Rights Act. Pay equity goes further. It requires that jobs mostly done by women and jobs mostly done by men be paid the same if the value of the work done is equal, even though the work may be different. Pay equity is not a new concept in Canada. It has been a protected right under the Canadian Human Rights Act since 1977. Pay equity protection under the CHRA requires an individual to file a complaint. This system has significant challenges. The onus is placed on employees to file complaints. There is unequal access, with the system being more accessible to unionized employees. Disputes can be lengthy, costly, and contentious. And this approach does not help everyone equally. That's why the federal government passed the Pay Equity Act. With this proactive approach to pay equity, the burden to file complaints no longer rests with the employee. The onus is now on the employer to ensure that employees in jobs commonly done by women are paid equally. This aims to prevent problems before they happen. 6 Canadian provinces already have legislated proactive pay equity regimes. In Manitoba, New Brunswick, Nova Scotia, and Prince Edward Island, the legislation covers public sector employers and employees. In Ontario and Quebec, the legislation covers both the public and private sectors. In the remaining provinces and territories, approaches vary. Some include pay equity protections as part of broader pieces of legislation. Others have no legislated pay equity protections at all. The Federal Pay Equity Act was passed by Parliament and received royal assent in 2018. The Pay Equity Act applies to federal jurisdiction employers with an average of 10 or more employees. This amounts to about 4,500 federally regulated employers, or about 1.2 million employees. This includes the federal private sector and industries like banking, communications, and interprovincial and international road, air, rail, and maritime transportation. It also includes federal crown corporations like Canada Post and Via Rail, as well as the federal public sector, for example, government departments and agencies, and the Prime Minister and Ministers' offices. The Act extends to parliamentary institutions such as the House of Commons, the Senate, the Library of Parliament, and Members of Parliament through the Parliamentary Employment and Staff Relations Act. The new law assigned new responsibilities to the Canadian Human Rights Commission. The Pay Equity Commissioner is a member of the Canadian Human Rights Commission. The mandate of the Pay Equity Commissioner is to promote women's equality by ensuring that federal, public, and private sector organizations value work done by women in the same way they value work done by men. To carry out the mandate, the Pay Equity Commissioner has a wide range of tools at their disposal, from binding orders to auditing powers and administrative monetary penalties. The Commissioner, supported by the Pay Equity Division, administers and enforces the Pay Equity Act by providing tools and guidance to employers, employees, and their representatives, resolving disputes, and ensuring compliance. Employers covered by the Act will be required to create and post a pay equity plan within 3 years of the date the Act comes into force. Employers with 100 or more employees, and those with 10 to 99 employees, some of whom are unionized, must make all reasonable efforts to establish a pay equity committee for the purpose of developing their pay equity plan. Employers with fewer than 100 employees and no unionized employees are not required to establish a pay equity committee, but may choose to do so on their own or at the request of an employee. A pay equity plan identifies job classes in the workplace by grouping together positions that are similar. It also determines which jobs are commonly done by women and which are commonly done by men. It determines the value of the work done in each of the job classes by assessing the skill, effort, and responsibility required in the performance of the work, and the conditions under which the work is carried out. The pay equity plan also calculates the total compensation in dollars per hour for each predominantly male and female job class, and it determines whether there are differences in total compensation between predominantly male and female job classes of equal value. If there are differences in compensation, employers are required to remedy those by increasing compensation. Employers must update their pay equity plan at least every 5 years and submit an annual statement. Employers covered by the Pay Equity Act are responsible for ensuring their employees earn equal pay for work of equal value. If the employer fails to comply, employees can pursue recourse under the Pay Equity Act. Some federally regulated employees are not covered by the Pay Equity Act and remain covered by the pay equity regime set out in the Canadian Human Rights Act. These include employees in workplaces with fewer than 10 employees, those employed by Indigenous governing bodies, persons not considered employees under the Pay Equity Act, such as governor and council appointees, local staff in Canadian offices overseas, or students in an employment program like the Federal Student Work Experience Program or a post-secondary co-op or internship program. Employees of territorial governments remain covered by their own territorial human rights statute or by the Canadian Human Rights Act, as is the case in Nunavut. Pay equity is an important measure in supporting gender equality in Canadian workplaces.